Alhamdulillahilladzi hadana li hadza wa ma kunna linahtadiya laula an hadanallah. Asyhadu an la ilaha illallah wahdahu la syarikalah wa asyhadu anna Muhammadan abduhu wa rasuluh la nabiyya ba'da. The Honorable Dr. Sajahart, LLM, Assistant Professor of Comparative Constitutional Law at Maastricht University in Netherlands. The Honorable Professor Dr. Aidul Fitrisyada, Azhari, SH, M.Hum, University Muhammadiyah of Surakarta, former Chief of Indonesia Judicial Commission. The Honorable Ferry Kovas, SH, LLM, Lecturer at Faculty of Law Muhammadiyah, University of West Sumatra. The Honorable Law Faculty of Muhammadiyah, University of East Kalimantan. Law Faculty of Bengkulu University, Law Faculty of Muhammadiyah, University of Yogyakarta, Law Faculty of Muhammadiyah, University of Mataram, Law Faculty of Muhammadiyah, University of Kota Bumi, Lampung, Law Faculty of Muhammadiyah, University of Tangerang, Law Faculty of Muhammadiyah, University of Jakarta, and Law Faculty and Family Law Study Program of Muhammadiyah, University of West Sumatra. Ladies and gentlemen, good morning. A very warm greetings to each and every one of you. Welcome to Yunahar Ilyas Convention Hall for the International Seminar on Comparative Law. I'm Shakira Amanda, the MC for this event. On behalf of the organizing committee, we extend our appreciation for your presence. On this special day, deans, lecturers, and students from several universities in Indonesia are gathering with us hybrid, online, and offline with delighted spirit and pride. They are all ready to gain knowledge about comparative law. Ladies and gentlemen, without further ado, let us start our program by listening Quran recitation by Salsabila. Time is yours.
Assalamualaikum warahmatullahi wabarakatuh. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Qasim. Tilka ayatul Qur'ani wa kitabim mubin. Hudan wa busyra lil mu'minin. Alladzina yuqimuna sholata wa yu'tuna zakah wa yu'tuna zakata wa hum bil akhirati hum yuqinun. Innalladzina la yu'minuna bil akhirati zayyanna lahum a'malahum zayyana lahum a'malahum fahum ya'mahun ulaika lahum su'ul adab wahum fil akhirati humul akhsarun wa innaka latulaqqal qur'ana min ladun hakimin alim Sadaqallahul azim. Assalamualaikum warahmatullahi wabarakatuh.
Singing National Anthem Indonesia Raya and Mars Muhammadiyah. Audience kindly requested to be raised. You may be seated. Well, ladies and gentlemen, let's welcome the Dean of Law Faculty of Muhammadiyah University of West Sumatra. To deliver his opening remarks, please welcome Mr. Wendra Yunaldi, SHMH.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. The Honorable Dr. Sasha Harsh, LLM, welcome to Bukit Tinggi. Dr. Sasha, an Assistant Professor of Comparative Constitutional Law at Maastricht University, Netherlands. Thank you for giving the time and sharing knowledge with us today face to face. The Honorable Professor Aidul Fitrisyada Ashari, Dean of Law Faculty of Muhammadiyah University Kalimantan. He was also the former chief of the Indonesian Judicial Commission. The Honorable Mr. Ferry Kova, LLM. He is lecturer at Law Faculty of Muhammadiyah University West Sumatra. He is the one who has actively contacted his friends, Dr. Sasha Harsh, so that we can meet him today face to face at the Muhammadiyah University West Sumatra. The Honorable, the Dean, the head of department or study program, the lecturer and student from Law Faculty of Muhammadiyah University of East Kalimantan, Law Faculty of Bengkulu University, Law Faculty of Muhammadiyah University of Yogyakarta, Law Faculty of Muhammadiyah University of Mataram, Law Faculty of Muhammadiyah Universitas of Kota Bumi Lampung, Law Faculty of Muhammadiyah University of Tangerang, Law Faculty of Muhammadiyah University of Jakarta, and big family of law faculty, including family law study program of Muhammadiyah University of West Sumatra. All praise to Allah, because today we can hold an international seminar on comparative law related to enforcing the code of ethics constitutional judge. This time is interesting because in the mid of the session of the Constitutional Court of Republic Indonesia, which is quite exciting and controversial regarding of the presidential candidate requirement, and also the session of the honorary course of the Constitutional Court, which stated that several constitutional courts judges violated the code of ethics. The international seminar is a follow-up action toward MOU between Muhammadiyah University West Sumatra and the Faculty of Law and Muhammadiyah University East Kalimantan, and several faculties of law also join together hybrid online and offline. Starting from this afternoon until tomorrow, there will be PBL, problem-based learning, workshop with Dr. Sasha. He will also provide an overview of the actual problem-based learning practice. Hopefully, the PBL method can be adapted and applied to our students to improve the learning process on our beloved campus. Finally, million thanks to Dr. Sasha for being here with us from the 3rd to 5th December 2023. Hopefully, this event will add our insight on comparative law and better understanding in legal learning. Amin. Thanks all. Thank you for your kind attention. Wassalamualaikum warahmatullahi wabarakatuh.
Well, ladies and gentlemen, this is the end of the opening ceremony of the International Seminar on Comparative Law. Now we are going to start our session about comparative law. Let me hand over this session to the moderator. Please be kindly invited to the stage, Ms. Susi Susanti, SPDI MPD.
Well, thank you, MC. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. Welcome to Unihar Izzas Convention Hall. Welcome to all participants. The Honorable Dr. Shasha Hart, LLM, Assistant Professor of Comparative Constitutional Law. The Honorable Professor Aidul Fitricia Azari, former Chief of Indonesia Judicial Commission, and Honorable Mr. Ferry Kofa, SH, LLM. There are three amazing speakers for us in international seminar for today. And also, honorable beloved audience, and also universities who are joining together with Sumbar to hold this program in international seminar on comparative law, violation code of ethics of constitutional court judge, and the impact of their decision on judicial review. This is our team in this international seminar. Well, ladies and gentlemen, without further ado, let's start our international session by let our first speaker, Dr. Shasha, to share his idea. And before letting this microphone to him, let me a little bit tell you about his CV in brief. So Dr. Shasha is an assistant professor of comparative constitutional law at Maastricht University in Netherlands. And he is currently coordinating the law faculty honors program. And also he has previously been affiliated to Erlangga University in Surabaya. And as adjunct professor has served as the coordinator of OKP or LEAP, Legal Education, Ethnic and Professionalism. And in this capacity, he has collaborated closely with 6 Indonesian faculties of law and 5 of which outside of Java, and helped to establish Jaringan Pendidikan Hukum Indonesia atau www.japid, which is delegated to innovation in legal education. He is also co-editor and co-author for Legal Education in 21st Century, Indonesia and International Perspective, and remain active in lecturing and providing training to legal staff in various universities in Indonesia. So, Dr. Shasha, time is all yours.
Thank you very much. Thank you very much, Mr. Dean, Madam Moderator, and thank you very much to my friend Ferry Kofa for bringing me here once again. It is a great pleasure to be back at this beautiful campus and to be able to talk to you in person once in a while, and not only through the screen as we have done repeatedly in the past. It's always a great pleasure to be here. So today's session, of course, has its reason, its occasion in recent developments, important developments that are taking place in Indonesian constitutional law. Since I am not Indonesian and I'm not an expert as such on Indonesian law, my role, as so often, will be to give a little bit of a comparative perspective on these things. Before I do so, let me give you my apologies for not being able to give my presentation in Bahasa today. I will do my best to speak clearly and distinctly, but since I come from a faculty where we engage in PBL, innovative teaching, and interactive lecturing, do feel free to interrupt me if there's anything that is not clear. I just, raise a question also while I'm presenting. It's not a problem. You can do that at any time. Now, so I've been asked to talk a little bit about the dismissal and possibility of disciplinary actions, and also the mode of appointment and the nature of the mandate of constitutional judges from a bit of a comparative perspective. Of course, this has been occasioned by the where are we? It has been occasioned by the recent decision of the Mahkamah Konstitusi on the age limits for political office holders or candidates for the vice presidential office, which not only in Indonesia, but I can tell you also in the wider world where this news has reached us, has led to some surprise and also some some lack of understanding. So it's maybe interesting to shed some light on it from a comparative perspective. I'm first going to very briefly recapitulate my understanding of the events that have taken place in the Mahkamah Konstitusi. Feel free to fill me up on this and feel free to correct me if I understood anything wrongly here. And then I'm going to use two countries as comparators for what is going on, or for the procedures that have been applied in the wake of these decisions. So the disciplinary hearings and the disciplinary decisions that have been taken against Justice Anwar Usman. And how that would have gone down, or what possibilities there are for such things to happen in both Germany, which is my own home country, and the United States, which of course is always a useful comparator, not because it is a perfect system, but because it is so well known throughout the world. And at the end, I try to reach some preliminary conclusions on what I think can be said about the goings on in the Indonesian Constitutional Court. And I'm very happy to discuss this with my fellow speakers and with you afterwards. So what happened? I tried to make my slides bilingual. I hope that the translation is somewhere near accurate. So the whole discussion started with the ruling number 90 of the Mahkamah Konstitusi on age limits for running mates or for candidates for the vice presidency of the Republic of Indonesia. On the day of these rulings, there were actually rulings or hearings on several motions that all related to the same matter. They had slightly different entry points. So one, for example, demanded that the alternative to fulfilling the age limit, you could also show political office holders experience. Another related to having participated and having won elected office before. So there were slight variations on the theme. However, both the reasons for the petitions submitted and also, I think in a general sense, the content of the submissions submitted were all very similar. In the first couple of rulings and hearings on that day, Justice Anwar Usman did not participate, ostensibly, not because he recused himself, so he did not say that there was a conflict of interest, but he claimed other reasons for being unable to participate in those hearings. And to my understanding, 3 petitions of a similar scope were dismissed by the court. Very surprisingly then, and I say surprising because colleagues of mine who have followed the news coverage, we need a translation? Okay. Colleagues of mine have told me that during the news coverage, the holding of the 4th hearing on that day was very surprising. Many journalists had already gone home because they had already thought, okay, the matter is settled. We now know that the age limit stands. And suddenly there was the hearing on the 4th position, in which surprisingly Justice Anwar did participate. It later emerged that he had apparently played a part in holding this meeting, And apparently also he did not recuse himself from this meeting. And in this last one, which was filed by a law student, and which was also, again, about the age limit, and which claimed that the age limit could be substituted for by having held elected office, including the office of mayor, or district head, which can be a mayor. It should be possible to run as a vice presidential candidate. And in this hearing, suddenly, by a narrow margin, but still, the Mahkamah Konstitusi granted the motion. So this is what happened. There were a number of readily apparent irregularities, or at least oddities, on this day. First of all, the non-participation of Justice Anwar in the previous hearings and rulings, and the sudden participation in this last one, which, by the way, in the petition text, it said was caused or was based upon the willingness of the son of the president to participate as a running mate. So there can be no misunderstanding about the motives for this lawsuit, right? So the participation of Justice Anwar, the withdrawal, because the action had been temporarily withdrawn and then reintroduced, the late moment at which the hearing was organized, and apparently co-organized or organized at the behest of Justice Anwar himself, and most of all, the sudden change of heart of the court, because on the very same day, the court had decided in what I would call virtually identical matters, at least very similar matters, in a totally different direction. So there is something strange about this lawsuit. Now, it is not for me, and we know for whom it is, to decide whether there actually were sanctionable irregularities in Indonesia. This is for the honorary council, the Dewan Kehormatan of the Constitutional Court. Now, the existence of this panel, of this honorary council, is based in law. So we have Article 27A of the Law 24 of 2003, which is the reason which gives rise to the existence of this honorary council, which is tasked with executing disciplinary actions and has the possibility for dismissal of the judges. There is a curiosity, though, about the way this panel is set up. Its existence is founded in the law, in a statutory act of parliament, but the competences and also the precise sanctions that it can issue come from elsewhere. They come, interestingly, from the court itself, right? So the competences of this honorary council, which is staffed by a representative of the court, by a scientific expert, and by a representative of the Judicial Committee, right? Yes, the Judicial Commission. So these three people are tasked with sanctioning or finding violations of the codes of conduct. But what they can do is regulated by the court itself. This looks unusual, to say the very least. Whether it's unconstitutional is again for the court to decide, so I cannot pronounce on it, but it looks at the very least unusual. So it is interesting to have a look at how these matters. So the mandate of constitutional judges in the first place, and also the possible disciplinary measures against constitutional judges are regulated elsewhere. So I would invite you to look at this together with me from a perspective of Germany. Just a first brief overview of what the court looks like in Germany. Oops. In Germany, we have a relatively large constitutional court consisting of 16 constitutional judges they sit in two different senates. So there are two chambers of constitutional judges. Each judge has a term of 12 years, so they don't sit for life. They have a relatively long term, but it's non-renewable. So 12 years, and then somebody is definitely out. How do you become a constitutional judge? Because also this is a curious matter which has been the subject of case law in the Mahkamah Konstitusi and of no, not case law, but of precedents in the Indonesian system. Because in Indonesia, several institutions have the right to each appoint a section of the court or part of the court, and in the past have interpreted this quite recently as implying the right to recall one of the judges. This also struck the international community of comparative constitutional scholars as very odd, because it is, first of all, the Constitution doesn't say anything about it. And second, it seems to be very much in conflict with the idea of judicial independence, because constitutional justices are not supposed to be agents of any organ of state. They are supposed to be independent arbiters. Now, in Germany, where do the judges come from? Half are elected by the lower house of parliament, the more powerful house of parliament, the so-called Bundestag, and the other half by the upper house of parliament. They are not elected all at once, because their term of office starts at different moments, so it also ends at different moments, and whenever there is a vacancy, a new replacement will be elected. Now, who can be a candidate? There we have a curious system based on a constitutional convention, which says traditionally that the largest parties in parliament can each take turns to propose a candidate. However, we must take into account that nowadays we have more parties in parliament, so this is softening a little bit. Also, smaller parties can propose, and importantly, whoever is proposed by whatever party, they will always have to be confirmed by 2/3 majority of the chamber. So there will have to be broad support. If you compare this to Indonesia, it would mean that a large support base and not a fractioned individual state organ could send somebody to the court. Now, this is already a crucial difference, but they are elected. They have some sort of democratic legitimacy. The proposal situation is changing a little bit, but the 2/3 majority stands. Now, what in case a German constitutional judge would violate codes of conduct or would misbehave in office, would somehow not perform their tasks? Mind you, what I'm telling you now hasn't happened. So we haven't had a situation where constitutional justice has been dismissed or had to face very serious disciplinary action. In principle, disciplinary proceedings against a judge of the Constitutional Court work in the same way if they are on a relatively low level as disciplinary proceedings against any other judge. Because disciplinary hearings that lead to impeachment can only be requested by the high state organs, by the lower chamber of parliament, the upper chamber of parliament, or the federal president. But the decision to impeach, or the decision to dismiss on impeachment, is for the court itself in a special grand chamber. You might say, is it so different from the Indonesian situation, where it's also the court which says which competences the Dewan Kehormatan has? It is different because there is two institutions involved. There must be an outside institution with a strong majority, either Chamber of Parliament or the federal president, who requests the whole proceeding. Nothing is going to happen without them willing it. And then the internal procedure takes place. So we have a split. We have at least two high state organs involved in the process. And that is quite a difference. If we turn over to the US, where, as you all know, Supreme Court justices are appointed famously for life, and life means life. They can literally be in office as long as they live, and some of them have been. Think of the late Ruth Bader Ginsburg, for example, or the late Antonin Scalia. Supreme Court justices appointed for life, as the Constitution says in Article 2, with the advice and consent of the Senate, which means they are appointed by the president, but they have to be affirmed by a majority of the Senate. First, a majority of the Judicial Committee, and second, a majority of the Senate plenary, which means that at least at some point in their career, they must have this type of majority before being appointed, but then they can sit for life. Typically, the appointment process, as you will certainly know, is a very politicized matter in the US. It's the judges, the current bench tends towards the confirmative side after a couple of appointments by President Trump. This can sway in the future, but generally, very often the bench is split along political lines. It is a political appointment process. However, let's get to impeachment. Supreme Court judges are very hard to remove. They are, when we take the political circumstances into account, they are virtually impossible to remove unless the infraction that they have committed is glaring, is obvious, and very, very severe. We can distinguish between smaller disciplinary matters, which can be investigated and sanctioned in the US through the Judicial Council, which is an institution that oversees the work of judges on all levels of the federal judiciary. So it is the same institution that also regulates disciplinary actions against federal district judges and so on at a lower level. But when it comes to dismissing them, so when it comes to the really serious infractions, and the Constitution defines those as treason, for example, or so-called high crimes and misdemeanors. So actual treason, bribery, high crimes and misdemeanors, which might be something that in the Indonesian case could have been at play or could at least have been discussed. Then the procedure for removing constitutional judges is the same as it would be for the president of the United States. So it means the House of Representatives have to file the so-called articles of impeachment, bring charges against the president and against the constitutional judge of the Supreme Court. And then the Senate has, with a 2/3 majority, which makes it very, very hard to do, to approve the impeachment and dismiss the court. So also here we see, while judges are hard to remove, when it comes to it, it is not the court itself that calls the shot alone, right? It is the other institutions which are involved. It is the legislator, the institution that brings with the Senate the justices into office that can also remove. Okay, so by and large, this is also what happens elsewhere. I gave you these two examples, but in other countries, it works in a similar way. Let's reflect on this a little bit. When the office and the actions and disciplinary sanctions against judges of highest courts and constitutional courts are involved, we need to balance two things. On the one hand, also just judges cannot be above the law. So when judges violate codes of ethics, codes of conduct, when they engage in criminal behavior, when they engage in corruption, or when they engage in anything else that would violate also the standing of the court in society, action needs to be taken. It must be possible to get rid of them. On the other hand, courts must be independent. The whole point of having a constitutional court is that it is independent. It is independent of the other political institutions. And this is why in Indonesia, this practice of recalling a judge because they displeased in their decision the institution that has appointed them is so troublesome and so unusual. But they must also be independent, for example, of family members. So judges, quite obviously, who have a personal interest, could be a family interest or a monetary interest, some investment, whatever, in a matter that the court is dealing with, are under an obligation to recuse themselves. This is quite normal and natural and obvious. This is I would say, a universal principle because it is at the very heart of having constitutional courts. Constitutional courts, just as having separate legislators and separate executive organs, are an expression of the trias politica. They are an expression of the desire to separate out, split out the branches of government into different institutions in order to allow them to keep each other in check. And the moment that they fail to do so, they also call into question the very reason for existence of the institution. The moment a constitutional court fails to act independently or fails to keep up the appearance to act independently by giving, a weird taste to a decision, as arguably happened in this case, this already damages the institution very much. Therefore, it is useful to have, on the one hand, not just a toothless tiger, so not just a procedure which might look good in paper, but in actual reality doesn't bite, but a strong procedure which can lead to decisive action. But it's also reasonable to have high thresholds. It is not easy, it should not be easy to get rid of a judge, but it should be possible. So in conclusion, in international comparison, the disciplinary action and dismissal of highest judges is typically either very tightly regulated. So what can you be disciplined for? In what way? What exactly can be the sanction? What is needed to bring the sanction into action, etc. Or it involves different state organs as well. So not just something that is essentially created by the court. The Indonesian disciplinary procedure is, in that sense, let's say, from a comparative perspective, at the very least strange. I keep it at that for the moment because probably this is going to have further legal repercussions in the country, so we don't know the end of the story yet. The ruling of the Constitutional Court regarding the age limits, that ruling which gave rise to the whole discussion, whatever you may think of its merits on the ground, and I'm not the expert on the Indonesian constitution to be able to call the shots on this case. I don't find anything controversial about a 40 years age limit, which is clearly stipulated in law. I don't think this has much need for interpretation, but you can have different opinions about this. But the ruling itself and the way in which it has come into being, there's no question that this has already damaged the institution. It has already damaged the standing of the Constitutional Court. So I suggest that it would be a good development if these disciplinary proceedings be brought in order in such a way that they work effectively in the future. Thank you very much.
Well, thank you, Dr. Sasha. Well, ladies and gentlemen, for discussion session will be held at the end after the three speakers present their points. Okay, so now for the second speaker, I would like to invite Professor Dr. Aidul Fitrisiada Azari, SH, M.Hum. Okay. So Professor Adu will be the last speaker today. Now let's go on to the second speaker, Mr. Ferry Kofa, SH-LLM. Before giving the time to Mr. Kofa, let me tell you a little bit CV of Mr. Ferry in brief. Mr. Ferry Kofa, SH-LLM, completed his bachelor degree at the Faculty of Law Andalas University in Padang, Indonesia, and then took master degree as Magister Juris Communis program at Faculty at Maastricht University, Netherlands, specialized on comparative law, and he is a civil servant who served as the Regency expert staff for law, politics, and government. Besides that, he is also a lecturer at Faculty of Law, Muhammadiyah University since 2009 until now. The subject he taught, right to examine the law, state administrative law, comparative law, Dutch language, international law, government procurement law, and state and local finance law. Well, Mr. Ferry, time is all yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. How are you doing? Fine, great. So welcome to the international seminar on comparative law. Selamat datang dalam seminar internasional comparative law. Salam dan kata-kata penghormatan kami tumpangkan saja pada pembicara sebelumnya. Baiklah, terima kasih atas kesempatan yang diberikan sebagai salah satu pembicara dalam seminar ini. Boleh saya berdiri ya? Ya. Baik, karena saya bawa juga bawa laptop, jadi mungkin untuk melihat apanya silakan nanti ada yang silakan share screen-nya dari ya. Ada operatornya. Baik, Pak Sasa tadi, Dr. Sasa sudah menyampaikan dalam perspektif perbandingan mengenai kode etik, penegakan kode etik dan disiplin dari hakim konstitusi. Namun kami lebih ke arah mengenai putusan dari MKRI nomor 90 21 PUU 2023 yang berkaitan dengan legitimasi dari putusan Mahkamah Konstitusi itu sendiri dalam perspektif hukum tentunya. Jadi baik, lanjut. Ya, kita lihat balik sekilas mengenai fungsi kekuasaan kehakiman. Ini yang pertama jelas adalah penegakan hukum. Penegakan hukum di sini tentu menjadikan hukum positif sebagai landasan. Kemudian yang kedua, ini kekuasaan yang menentukan hukum dalam kasus-kasus hukum konkret yang itu tidak diatur di dalam hukum positif. Jadi ibarat dikatakan pernah disampaikan dalam opini hukumnya oleh Ketua Hakim Federal Amerika Serikat dalam kasus Marbury versus Madison yang melegenda dalam terkait dengan pengujian undang-undang. It is the duty of judge to say what the law is. Ya, jadi ini merupakan tugas hakim lah untuk menentukan apa yang menjadi hukum tersebut. Tentu dalam keadaan tidak ada hukum positif yang bisa dijadikan landasan ataupun sandaran. So the judicial power decide the case that are not provided by the positive law where court decision become procedure. Next. Lanjut. Ya, kita lihat di sini ada prinsip-prinsip pokok kehakiman, kita ambilkan dari Bangalore Principle of Judicial Conduct. Yang 1-2 itu jelas secara kelembagaan itu adalah prinsip kelembagaan dari kekuasaan kehakiman. Harus independen dan harus imparsial. Jadi independen, tidak bisa diintervensi oleh siapapun dalam menyelesaikan perkara yang ditanganinya. Kemudian tidak berpihak kecuali kepada hukum itu sendiri. Nah, kemudian yang poin berikutnya itu berkaitan dengan personality. Jadi ini kepribadian dari hakim itu sendiri yang berkaitan dengan integritas, kepantasan, kesetaraan maupun kecakapan dan kesesamaannya. Next. Kita lihat review lagi, ada kompetensi Mahkamah Konstitusi, ada beberapa di sana, pengujian konstitusionalitas undang-undang, memutus SKLN, sengketa kewenangan lembaga negara yang kewenangannya diberikan oleh Undang-Undang Dasar, memutus pembubaran partai politik, dan memutus PHPU, perselisihan hasil pemilihan umum. Next. Dan ini adalah fungsi-fungsi dari Mahkamah Konstitusi ya. Yang pertama adalah pengawal dan penjaga dari konstitusi. Kemudian penafsir akhir, the final interpreter of the constitution. Kemudian sebagai pengawal demokrasi, penjaga demokrasi, kemudian pelindung hak-hak konstitusional warga negara, serta penjaga atau pelindung dari hak asasi manusia. Lanjut. Nah, ini saya masuk ke merit dari kasus yang diputus oleh MK melalui putusan nomor 90 2023 itu sendiri. Fakta-fakta kasusnya bisa kita lihat di sini. Yang pertama itu pemohon jelas seorang mahasiswa warga negara Indonesia. Kemudian pemohon merasa dirugikan hak konstitusionalnya sebagai capres atau cawapres karena adanya persyaratan pembatasan usia minimum 40 tahun ya. Dan itu dituangkan dalam pasal 169 Q Undang-Undang 7 2017 tentang pemilu yang dianggap bertentangan dengan pasal 27 ayat 1, pasal 28 D ayat 1 dan 28D ayat 3 Undang-Undang Dasar 1945. Pemohon ini juga seorang pengagum, penggemar dari Gibran Rakabuming, Wali Kota Surabaya. So the applicant is also a fan of Mayor of Surakarta, Gibran Rakabuming. In this context, he is also a son of Indonesian President Joko Widodo. Next. Adapun yang dijadikan argumen dalil dalam gugatan itu adalah ketentuan pembatasan syarat usia minimum tadi telah menghalangi hak kaum muda untuk maju sebagai capres atau cawapres karena dianggap bertentangan dengan hak untuk mendapat perlakuan dan kesempatan yang sama di depan hukum dan dalam pemerintahan serta hak untuk bebas dari perlakuan diskriminatif sebagaimana dimaksud di dalam pasal 27, 28, 28D ayat 1 dan 28D ayat 3 di slide sebelumnya. Next. Nah, apa yang menjadi gugatan pokok permohonan dari pemohon aplikan? Itu pemohon meminta ketentuan syarat usia minimum capres, cawapres bertentangan dengan Undang-Undang Dasar 1945 sepanjang tidak dimaknai dengan syarat alternatif. Syarat alternatifnya tambahannya di sini adalah berpengalaman sebagai kepala daerah, baik itu di tingkat provinsi, kabupaten, atau kota. Nah, dalam putusan 90 tahun 2023 ini yang menjadi pertimbangan-pertimbangan dari Hakim Konstitusi yang bisa kita baca dalam putusan itu antara lain yang pertama, meskipun syarat Capres Cawapres itu adalah kewenangan legislator sebagaimana yang dinyatakan oleh Undang-Undang Dasar, ini adalah disebut juga dengan open legal policy ya. Jadi kewenangan dari DPR tapi tidak mengenyampingkan kewenangan MK sendiri untuk memberikan solusi konstitusional dan tafsir akhir dari konstitusi. Nah, itu yang pertama. Yang kedua, di dalam pertimbangan MK juga menyatakan bahwasanya di dalam persidangan sendiri DPR dan Presiden sudah menyerahkan sepenuhnya kepada MK untuk menafsirkan dan memutuskan. Nah, ini yang gawatnya nih. Nah, kenapa DPR tidak mempertahankan ya bahwasanya kewenangan syarat capres cawapres itu harusnya adalah menjadi kewenangan DPR untuk menentukan, karena di Undang-Undang Dasar sudah ditentukan bahwasanya syarat capres dan cawapres itu adalah diatur dengan undang-undang. Jadi tentu MK tidak berhak untuk menafsirkan apalagi sampai membuat norma baru seperti yang ada sekarang. Nah, jadi in the testimony at the trial, DPR is a House of Representatives left it entirely up to the MK to decide upon this matter. Kemudian penambahan syarat alternatif tersebut menurut MK telah memenuhi prinsip minimum degree of maturity and experience dan prinsip memberikan kesempatan dan menghilangkan pembatasan secara adil, rasional, dan akuntabel. Jadi MK ada menyatakan adanya syarat alternatif itu telah memenuhi prinsip ya. Kalau saya sendiri juga tidak tahu dari mana prinsip, apakah ini di dalam hukum administrasi atau apa, ataupun di ilmu politik, ini minimum degree of maturity and experience ya. Jadi batasan minimal kedewasaan dan pengalaman seseorang. Nah, jadi dianggap berpengalaman sebagai kepala daerah itu baik kabupaten kota maupun provinsi itu dianggap sudah memenuhi prinsip kematangan, ya, prinsip minimum kematangan dan kedewasaan dalam politik. Tapi kalau kita lihat sebagaimana disampaikan juga oleh Dr. Sasa tadi, kita di Indonesia politiknya masih kematangan itu bukan melalui proses, not by process. Ya, jadi it depends, maybe it depends who is your father. Ya, misalnya, tergantung siapa bapaknya misalnya. Nah, jadi nepotisme itu masih sangat mempengaruhi, ya. Next. Jadi ini yang menjadi pokok-pokok pertimbangan MK dalam putusan tersebut. Nah, apa putusan dari MK sendiri? Yang pertama itu menerima permohonan pemohon untuk sebagian. Yang kedua, pasal syarat usia minimum itu dianggap bertentangan oleh MK dengan Undang-Undang Dasar 45 sepanjang tidak dimaknai dengan syarat alternatif yang bunyinya adalah atau berpengalaman sebagai kepala daerah baik tingkat provinsi, kabupaten atau kota. Dalam konteks ini adalah gubernur, bupati atau wali kota tentunya. Nah, ini putusan the court's ruling dari MK sendiri. Next. Nah, ini fakta-fakta yang bisa kita lihat dari putusan MK itu sendiri. Yang pertama, ada inkonsistensi dengan beberapa putusan-putusan sebelumnya. Ini sangat mengejutkan. Nah, istilahnya mungkin dalam bahasa Wawa, pemirsa waktu itu takicuah dengan tarang. Ya, paginya diputuskan 3 putusan 21, 50, 55 putusan MK itu menolak permohonan penggugat. Ya, in this morning MK decides three rulings that they're not granted the applicants. Jadi ada 3 apa yang ditolak. Jadi ada inkonsistensi dengan putusan sebelumnya. Sorenya sudah mengabulkan dengan syarat tambahan tadi. Ya, syarat berpengalaman tadi. Kemudian dikabulkan dengan kondisi 5 orang setuju, 4 dissenting opinion. Ya. Nah, di antara yang 5 orang yang setuju itu ada juga 2 hakim yang setuju dengan putusan, tapi berbeda dengan pendapat, concurring opinion. Ya. They are in favor of that the alternative requirements is that stated that has an experience as a governor, not included the experience as a major or regent. Jadi 5 orang setuju, 4 yang dissenting. Jadi 2 dari 5 yang setuju itu 2 juga berbeda pendapatnya. Yang 2 itu menyatakan mereka setuju dengan syarat tambahan, tapi bukan syarat berpengalaman sebagai bupati wali kota, minimal sebagai gubernur. Kemudian fakta lainnya ada pelanggaran etika oleh hakim yang memiliki konflik atau benturan kepentingan dalam putusan tersebut, dan ini pelanggaran tersebut sebagaimana kita ketahui sudah diputus oleh Majelis Kehormatan MK. Jadi itu adalah hakim ketua sendiri, ketua Mahkamah Konstitusi sendiri, yang beliau sebelumnya Pak Anwar Usman ini tidak terlibat di 3 putusan sebelumnya yang pagi hari. Ya, tapi siangnya sudah ikut. Nah, sebagai ketua. Jadi beliau ini memiliki konflik kepentingan secara tidak langsung. Karena si pemohon tadi adalah sudah menyatakan dia adalah pengagum atau penggemar dari Gibran Rakabuming ini. Gibran dalam konteks ini akan maju dalam sebagai cawapres. Kemudian yang ketiga keanehannya, fakta-faktanya, MK membuat norma baru yang seharusnya menjadi kewenangan DPR. Jadi MK menambahkan syarat alternatif tadi. Jadi syarat alternatif ini berarti sudah menambahkan norma baru. Dalam konteks ini MK telah mengubah fungsinya tidak hanya sebagai negatif legislator, tapi mereka juga sudah menjadi positif legislator. Jadi padahal di Undang-Undang Dasar sudah dinyatakan bahwasanya syarat capres, syarat cawapres itu diatur dengan undang-undang. Yang berwenang membuat undang-undang tentu adalah DPR. Kemudian yang berikutnya ada indikasi ketidakseriusan DPR dan pemerintah selaku pihak pemberi keterangan di persidangan yang sudah saya sampaikan di rasio decidendi atau pertimbangan putusan hakim tadi, bahwasanya DPR dan Presiden sudah menyerahkan masalah ini sepenuhnya untuk diputus oleh MK. Jadi kalau DPR-nya sekarang heboh-heboh juga, salah mereka sendiri waktu itu. Kenapa tidak serius dalam persidangan tersebut dalam memberikan keterangan? Mereka harus mempertahankan argumen itu kenapa usia 40 ini yang menjadi syarat di Undang-Undang Pemilu. Tapi malah menyerahkan sepenuhnya kepada MK. Dan MK itu dianggap sebagai jalan landasan bagi mereka untuk memutus lebih jauh dengan menambah syarat alternatif tadi. Ya, next. Lanjut. Nah, bagaimana legitimasi dari putusan ini? Ini dalam perspektif hukum, menurut kami ada beberapa hal yang dijadikan landasan di sini. Yang pertama pasal 10 ayat 1 dan pasal 47 Undang-Undang Mahkamah Konstitusi. Di sana dinyatakan bahwasanya putusan MK itu adalah putusan peradilan pada tingkat pertama dan terakhir yang putusannya bersifat final dan telah mempunyai kekuatan hukum sejak diucapkan dalam pleno terbuka untuk umum. Jadi jelas ini pertama dan terakhir, berarti tidak ada upaya hukum lainnya. Jadi langsung bersifat mengikat sejak diputuskan. Kemudian terkait dengan putusan tidak sah dan harus diperiksa kembali, sebagaimana bisa kita lihat di dalam pasal 17 ayat 5, 6, dan 7 dari Undang-Undang Kehakiman 2009, 48/2009, menurut hemat kami ini tidak bisa diberlakukan karena di Undang-Undang Dasar sendiri terkait dengan kewenangan MK, kemudian di Undang-Undang MK sendiri yang merupakan lex spesialis dari undang-undang tersebut dari MK, putusan MK itu di tingkat pertama dan terakhir dan juga final and binding. So the invalidity ruling due to the conflict interest according to the Judiciary Act cannot be invoked in this case. Lanjut. Kemudian ada satu prinsip juga kita bersama, prinsip dalam peradilan, satu adagium dalam bahasa Romawi, res iudicata pro veritate habetur. An issue that has been settled definitely settled by judicial decision. So it is must be honored. Jadi apa yang telah diputuskan oleh hakim itu dianggap benar. Ya, ini demi menjaga kewibawaan dan martabat dari peradilan itu sendiri, sekalipun itu salah, ya. Jadi walaupun ya ada pelanggaran kode etik dalam konteks ini yang sesuatu yang sangat memalukan tentunya. Jadi apa yang telah diputuskan oleh hakim itu dianggap benar. Next. Kesimpulannya, yang pertama, putusan MK 90/2023 itu memiliki legitimasi secara hukum dalam perspektif konstitusional, yuridis, normatif maupun prinsip res iudicata. Meskipun ini terciderai ya dengan pelanggaran kode etik dari salah satu hakim yang memiliki benturan kepentingan. Kemudian yang kedua, MK dalam putusannya ini menjadi positif legislator dengan menambahkan norma baru di dalam putusan tersebut, norma baru Undang-Undang Pemilu itu sendiri, pasal 169Q Undang-Undang Pemilu itu sendiri. Lanjut. Nah, barangkali untuk rekomendasi dari kami sendiri, yang pertama mengingat personalitas hakim ya, sebagai seseorang yang sangat mulia ya, yang khususnya hakim konstitusi itu syarat-syaratnya dinyatakan harus memiliki integritas dan kepribadian yang tidak tercela. Nah ini ya kemana dicari lagi nih hakim yang seperti itu, kata Bu Sukmarini ya. Kemudian hakim itu harus just and fair ya, adil. Kemudian hakim konstitusi ini tambahnya berat lagi, statesmanship. Dia negarawan yang memahami dan menguasai, paham dengan konstitusi. Nah, kalau istilahnya ini hakim sendiri, apalagi hakim konstitusi sudah melakukan pelanggaran kode etik, istilahnya tongkat itu atau pondasi itu yang sudah membuat roboh rumah itu sendiri ya. Tungkik yang membawa rabah. Ya. Nah, kemudian yang kedua, jadi perlu dipertimbangkan kembali menurut hemat kami. Tadi Pak Sasa juga sudah menyampaikan penegakan disiplin dan kode etik hakim di Jerman dan Amerika. Ya, jadi agak berbeda ya. Kalau di Jerman itu melalui Federal President dan Senat, Bundestag, Bundesrat. Jadi melalui parlemen. Nah, kemudian kalau di Indonesia kan cuma 3 orang. 3 orang, satu mantan ketua Mahkamah Konstitusi, satu dari hakim konstitusi itu sendiri, satu lagi dari profesional, istilahnya akademisi. Ya, yang terakhir kemarin Profesor Binsar Saragih ya. Jadi ini kemarin juga dalam putusan MK itu Pak Jemli sudah menyampaikan ini perlu jadi kajian juga mengenai MK ini, Majelis Kehormatan ini, baik susunan, kedudukan dan fungsi dan tugasnya. Ya. Jadi mungkin barangkali juga melibatkan Komisi Yudisial atau melibatkan istilahnya mungkin untuk check and balance-nya lembaga kekuasaan lain seperti DPR dan juga pemerintah. Kemudian rekomendasinya yang terakhir itu MK kedepannya mungkin perlu untuk lebih membatasi diri untuk tidak terjebak menjadi positif legislator ya. Jadi khususnya dalam pengujian konstitusionalitas suatu undang-undang. Jadi karena bagaimanapun tugas legislator itu adalah sudah menjadi lembaga, ada lembaganya sendiri. Jadi parlemen ataupun DPR kalau di Indonesia dengan persetujuan bersama dengan presiden. Itu saja barangkali dari kami, presentasi ini berkaitan dengan legitimasi putusan MK 90 2023. Mungkin nanti akan lebih berkembang dalam diskusi. Terima kasih. Billahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Okay, well, give applause for our speakers. Well, ladies and gentlemen, now let's invite our last speaker today, Professor Dr. Aidul Fitri Siada Azhari SHM Hum. Is he here already? Then I will, is he connected already? Belum join. Oh, okay. Okay, okay. Well, for this moment, Professor Akdul has a trial to attend, as a meeting to attend in the court. So we are going to have discussion session. You can address your question to Dr. Sasha or to Mr. Ferikova. Now, time is yours, audience, to ask question or to give opinion and share your ideas in any language you like. Well, for this session, I would like to open 3 questions from the people in this convention hall. We got 3 already, 1 from lecturer, and then 2 from students. So you girl, Sonia will be the one, and also Dimas will be the third one. Okay. Can somebody hand over the microphone to Mr. Yon, please? To Pak Yon.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much, Mr. Sasha, Dr. Sasha, Mr. Ferikova, and MC. Susi Susanti, bukan Susi Pujiastuti gitu. Saya ya separuh-separuh nih, bahasa Inggris sedikit-sedikit, bahasa Indonesia lebih banyak gitu MC ya. Baik, setelah kita dengar paparan from Mr. Sasha and from Mary, kemudian saya melihat di sini apa yang dipaparkan tadi, ada dua ilmu di sana. Ilmu hukum acara di Mahkamah Konstitusi, yang kedua adalah kode etik. Itu diatur ya 24 tahun 2003. Sedangkan masalah kode etik adalah peraturan Mahkamah Konstitusi nomor 1 tahun 2023. Nah, setelah kita dengar paparan tadi, saya masuk kepada substansi dari kasus nomor 90 tadi. Ya, dimana kalau kita ikuti, kita sangat setuju dari pendapat Prof. Jimli Asidiki, Prof. Yusil Iza Mahendra, Prof. Indrayana, Prof. Ya kita lupa dari Sumatera Utara, yang menyebutkan bahwa putusan itu adalah cacat hukum. Ya, kalau saya pribadi sependapat. Kenapa demikian? Kita lihat dari awal legal standing dari pemohon. Ini mohon maaf saya kalau salah koreksi ya. Tadi ada kata-kata penggugat. Menurut pasal 29 ayat 1 Undang-Undang 2003 tentang hukum acara, tidak berlaku lagi kata-kata penggugat di sini, yang adalah pemohon. Itu dasar hukumnya atau ground rule-nya adalah 29 ayat 1 Undang-Undang 2003. Jadi kalau salah tolong dikoreksi, tapi itu dasar hukum yang saya sampaikan. Dilihat legal standing dari pemohon, Almus itu ya, dari mahasiswa Universitas Solo itu memang udah melanggar kode hukum acara. Pertama dia ajukan legal standingnya, kemudian ditarik lagi, kemudian diajukan lagi. Menurut hukum acara itu tidak dibenarkan kecuali konstitusional yang berbeda. Itu yang pertama. Yang kedua, kita melihat ada di sini ultra petita yang dilanggar, ya, dilanggar oleh yang mulia majelis hakim yang ada di MK itu. Yang ketiga, ini ada kaitannya tadi, di mana kalau ada kaitan keluarga, itu hakim tidak dibenarkan untuk menyidangkan suatu perkara yang kita kenal dengan nemo iudex sine indosian probia in causatia. Itu tidak dibenarkan. Tapi inilah yang terjadi di kasus 90 ini. Kemudian lagi, dalam posita dan petitum juga ada hal-hal yang dilanggar. Jadi oleh karena itu, secara Undang-Undang nomor 24 tahun 2003 tadi, kita sependapat, itu yang dasar kita tadi, sependapat dengan profesor-profesor yang diajukan, yang dinyatakan dalam perkara ini. Tapi kita sayangkan ya, satu sisi ini konsisten ya, Pak Yusril Iza Mahendra, Pak Mahfud MD mengatakan bahwa putusan cacat hukum. Tapi di sisi lain beliau juga mendukung Gibran menjadi calon presiden. Ini enggak, kalau saya enggak sependapat ini. Ya kita harus konsisten, walaupun itu profesor. Ya yang kita minta di sini konsistensi dari seorang yang menyampaikan itu. Ya, yang katanya tegakkan kebenaran selagi walaupun langit akan runtuh. Itu cuma adegium sampah itu bagi orang-orang yang mengatakan seperti itu. Konsisten yang ini. Nah, kemudian masalah kode etik. Dengan adanya putusan-putusan yang disampaikan oleh Mr. Ferikopa tadi, 90, ini timbul pertanyaan ini. Karena di putusan itu ada CO, ada DO, concurring opinion dan ada dissenting opinion. Nah, pertanyaan saya kepada Mr. Sasa, kalau terjadi hakim aja, hakim sama hakim, hakim majelis itu atau hakim panel itu berbeda pendapat, kenapa dalam putusan MK ini final and binding gitu? Seolah-olah putusan hakim itu apa yang disampaikan statementship tadi. Dia lebih pintar lagi daripada malaikat, lebih bersih lagi daripada malaikat. Tidak ada upaya, sedangkan di PN ada upaya hukum, banding kasasi PK. Kemudian di PA gitu juga, di militer ada juga. Kenapa di MK ini seolah-olah dialah yang the best? Ini, itu ya. Jadi pertanyaan saya, apakah di Eropa sana putusan MK ini juga memakai sistem final and binding? Tuh. Yang kedua, apakah pertanyaan yang kedua, apakah kasus 90 ini masalah substansi bisa enggak merubah putusan kepada kode etik? Di Indonesia udah jelas dipisahkan ya, substansi, kode etik. Apakah di Eropa ini berlaku atau tidak? Yang ketiga, yang terakhir adalah apakah hakim Mahkamah Konstitusi ini di Indonesia akan diambil dari Mahkamah Agung, dari tokoh masyarakat, intelektual dan lain sebagainya. Apakah sistem rekrutmen di Eropa seperti ini juga atau berbeda? Terima kasih. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Well, ladies and gentlemen, since now our third speaker already been here with us, so let's postpone the discussion session so you can prepare the answer. And now I would like to invite Professor Dr. Aidul Fitrisiada Azari SHM to deliver his ideas. Then let me tell you the brief CV of Professor Dr. Aidul. He was born in January 1st, 1968, and then he received his bachelor degree in law in 1991 in Department of Constitutional Law in Pajajaran University, Bandung. And at the same university, he earned his master degree in 1999. His doctoral degree was completed in Department of Constitutional Law in Faculty of Law, Universitas of Indonesia in 2005. And then he spent his school days in Tasikmalaya, and he is actively writing books and scientific journal, as well as attending training in Indonesia and also abroad. And one of papers he wrote in International Conference Philosophy History in Istanbul in May 14 to 15, 2015, entitled The Philosophy of Manunggaling Kawula Gusti, from Javanese mythicism to Indonesian state ideology. And he also a former chief of Indonesian Judicial Commission from 2016 to 2018. And now he is also act as a dean of law faculty. Now, please welcome Professor Dr. Aidul Fitrisiada Azari SHM. Time is all yours, Prof.
Okay, thank you. First of all, Assalamualaikum warahmatullahi wabarakatuh, and good evening. Oh no, good morning. The Honorable Dr. Sasahart and Ferry Chopa, SILM, and of course, my colleague Miss Dr. Wendra, as Dean of University Muhammadiyah at Western Sumatra. I apologize because at the same time, I have an agenda to give examination for in promotion doctor in UMS, in the University Muhammadiyah Surakarta. I would like direct to post to share screen my PowerPoint. Okay, this is my PowerPoint, and my title of the PowerPoint is Violation of Judicial Ethics in Constitutional Court and its impacts to judicial review. Can see my PowerPoint? Moderator?
Yes, we can see it.
Okay, thank you. Okay, I have my systematic favorites. There are four part: code of ethics for constitutional justice, violation of judicial ethics enforcement, violation of judicial ethics in constitutional court, particularly in Indonesia, yeah, and the impact to judicial review. Okay, so I have a problem with okay. For the first, but code ethics. We know that about judicial ethics of Indonesian Constitutional Court is regulated in Constitutional Court Regulation or Peraturan Mahkamah Konstitusi number 9 of 2009 or 2006 about enforcement of code of ethics and conduct for constitutional justice, or we call Sabta Karsa Hutama. This is the Javanese language. I believe orang Minang, yeah, people for Minang, it is difficult to understand Sabta Karsa Hutama. And the others regulation in Peraturan Mahkamah Konstitusi number first year 2023 regarding Constitutional Court Honor Assembly. It is a new regulation. And Code of Ethics and Conduct for Constitutional Justice or Constitutional Judges refers to Bangalore principle. It is a universal instrument of international about judicial conduct, and Decree of the People Consultative Assembly, ketetapan MPR number 6 MPR 2001 regarding ethics of national life, etik kehidupan berbangsa. And the Code of Ethics for Constitutional Justice and its application is used as a reference and benchmarks in assessing the conduct of constitutional justice. So I want to direct and want to focus in Code of Ethics. Maybe for legal comparative, I hear from Mr. Dr. Sasa Hart in the first time gave a clear comparative law between German and other country and Indonesia. About Code of Ethics, Code of Ethics for constitutional justice is there is 7 principles, namely independence or kemandirian, impartiality, integrity, propriety, kepantasan dan kesopanan, equality, kompetensi and diligence, and wisdom. This is kearifan dan kebijaksanaan is I don't know what the different arif and bijaksana, but wisdom dan kebijaksanaan, and wisdom is living values within Indonesian society. There is a code of ethics that written in the Sabta Karsa Hutama. So the judicial conducts conceptually divided into 2 conducts. The first, pure conducts. It is the conducts, individual conduct as a person that related to status as a judge and has no direct impact to case. This is pure conduct, particularly concerning integrity, propriety, and wisdom there, and no direct impact to case. This behavioral, individual behavioral, like such as drunk, sexual abuse, cohabitation. In Indonesia, cohabitation is illegal, and illegal marriage. For instance, in some case in Judicial Commission of Indonesia, there is illegal marriage because Indonesia formally is monogamy, but there is some case where the some judges have a legal marriage, and it is the violation of code ethic in Indonesia. And the other, like perjury. Perjury is sumpah palsu. This is the pure conduct and has no direct to impact to case, has no direct relation to case. The other, the second is judicial conduct. It is the conduct in related with performance as judge in adjudication and decide cases, and has consequence to cases. And it is correlated with professionalism of justices, like for instance, secret meeting with advocate or secret meeting with advocate has conflict of interest in handling case, like case of Usman, the Chief Justice of Mahkamah Konstitusi, Mr. Professor Usman. This is, I think, it is the category that I know. It is the global. It is general category in judicial conduct. Not only in Indonesia, but in the other countries. I think I hear in Europe, in the other countries, the judicial conduct divided into two conduct: pure conduct and judicial conduct. And this is needed to distinguish between the conduct with individual and conduct and that correlated with performance. Then, based on the classification of judicial conduct, we can judge about the violation of code of ethics and conduct that give consequence or give impact to decision. Before I give the case of Indonesia, I think we have to know about jurisdiction. Then, and Mr. Sasha Hart, I hear he has explanation about jurisdiction in Indonesia and the other country. But in Indonesia, based on the case judicial review on law and the Republic of Indonesia number 22 years to 2022 year 2004 concerning judicial commission. This is the undang-undang about judicial about commission judicial. The enforcement of judicial conduct of constitutional judges is separated from the judges and the judges under the Supreme Court. And for from this decision, there is two code of ethics for judges in Indonesia. Code of ethics for general judges, and code of ethics special for commission for constitutional judges. And the enforcement of judicial conduct for judges and justice under Supreme Court is committed externally by Judicial Commission. and internally by supervisory body of Supreme Court, Badan Pengawasan Mahkamah Agung. So, and for judges and justices under Supreme Court, there are two supervisor by Judicial Commission and by supervisory body. This is I have no information how about effectivity of two body in enforcement and judicial conduct for justice under Supreme Court, because the new cases, the recent cases, there are two justice of Supreme Court that engaged in corruption. Yeah, there is who is and one of justice is of Supreme Court is I very know he is Gazalba. Yeah. The enforcement of judicial conduct for constitutional justice or for constitutional judges is committed by Constitutional Justice Ethic Council, Dewan Etik Mahkamah Hakim Konstitusi, and Constitutional Court Honor Assembly, Mahkamah Kehormatan Mahkamah Konstitusi. So there is two body, there is two organ in one institution in a constitutional court. A Constitutional Justice Ethic Council. This is for special. This is for the violation that the sanction is verbal impairment, verbal warning, and writing warning. But a Constitutional Court Honor Assembly, this is particularly for gross violation of judicial ethics. This is the cases between 2011 and 2023. There is Arshad Sanusi, he is resigned because the violation is allowing the family to meet the litigant. Akil Muhtar is very popular because his corruption and his dishonorable dismissal. Arif Hidayat, he is give his writing letter to Attorney General to promote career of his family, and his family is as a prosecutor, and he gets sanctioned for verbal reprimand. Patres Akbar, it is I think it is very popular. It's honorable dismissal because corruption. Arif Hidayat, it is the second sanction verbal reprimand. Yeah. In the peraturan Mahkamah Konstitusi, constitutional courts regulation, if the one justice get 3 reprimand, he has to face the Mahkamah Kehormatan Konstitusi. So when in 2023, all justice, including the Arif Hidayat, gets verbal reprimand. I think based on the regulation, Arif Hidayat has to be examined by Mahkamah Kehormatan Konstitusi. And in 1 year, in 2023, there is 3 cases. Guntur Hamzah, he had written a reprimand because changing process of decision without consent of the other justices, and all of justice This is very dramatic, I think, because all of justice, the 9 justice of constitutional court got a verbal reprimand because disclose confidential information to public about the process of consultation or deliberation between justice to decide the cases. This is, I think, it is very, very, very critical because disclose confidential information to public about the result of deliberation of between justice is I think it's gross violation, but the sanction is for the only verbal reprimand. And Anwar Usman, it is very popular because he gets dismissal as Chief Justice because the violation is conflict of interest, violation of independence and impartiality. Based on the data, the violation of judicial ethics will impact to judicial review cases on or constitutional court decision when it concerning with judicial conduct, not pure conduct. That according to a normal logic, or normal observation, in peraturan Mahkamah Konstitusi, is menurut penalaran normal dan pengamatan normal. And according to normal logic and normal observation will influence, will give impact to judicial decision. So this is the gross violation. This is the judicial conduct, not pure conduct. So from data above, the violation between 2011 and 2017 concerning pure conduct that indirectly related to judicial decision, and I think it is normal if the ethic commission, the ethic council give only the reprimand. But the violation during 2023 are concerning judicial conduct that possible or potential to influence the judicial decision became partisan and unfair. For the case Soda Gibran, or the son of president, the son of Jokowi, it is clear that the violation judicial conduct give opportunity to son of Jokowi to candidacy in as a vice president. Okay. Principally, decision of ethical violation cannot be used and no constitutional court decision due to different regime. The violation of ethics is a regime of ethics, and constitutional court's decision is a regime of law. Decision of ethical violation is part of ethical regime that concerning violation of judicial conduct. Adjudication of ethics is different from the adjudication of law in constitutional court. I know this when I talk about it in talk about it with my colleagues in judicial commission in other country. This is I think this is similar. This is there is similar opinion that decision of ethical violation is cannot change the court decision. It is clear, but in there is we can read in the decision of Mahkamah Kehormatan state that Majelis Kehormatan tidak berwenang menilai putusan Mahkamah Konstitusi. there is no authority to judge the decision of Constitutional Court as a law product, as the law regime. It is clear. Yeah. But, however, regarding conflict of interest issue in one case, law of judicial power to 2019 regulates that a case can be committed, can be re-examination with the different composition of justice. We can article in article 17, yeah, and law of the judicial power. Therefore, that issue, Mahkamah Kehormatan consider that pasal 17 ayat 6 dan 7 Undang-Undang 48 2004, this is Judicial Power Act, tidak dapat diberlakukan dalam putusan perkara pengujian terhadap Undang-Undang 1945 oleh Mahkamah Konstitusi. It is this is legal stand, a legal opinion from the Mahkamah Konstitusi. But I think there is the problem with the re-examination in Constitutional Court, because in law of judicial power 2019, the re-examination has to be committed by the different composition of justices. And in Constitutional Court, there is one only Justice Assembly. There is no there is no Justices Assembly. So this is the problem for the re-examination by the Constitutional Court. I think based on the consideration, the Mahkamah Kehormatan states that pasal 17 cannot be applied in decision of judicial review. Accordingly, the Constitutional Court considers in case number 141, 2023, that the re-examination, this is the decision, the new decision of judicial review decision from the Constitutional Court, that the re-examination of Constitutional Court decision has to reject it, because decision of judicial ethics cannot be used to judge or to evaluate Constitutional Court decision. And the regulation of re-examination according to Article 17 of law of judicial power cannot be applied in judicial review case of Constitutional Court. In fact, Article 17 law of judicial power cannot be applied because re-examination must be committed by different composition. And we know the Constitutional Court has only one Justice Assembly for all cases that final and binding. So when the same Justice Assembly hear the cases, the same cases, I think the result is unfair. And maybe partisan, and not maybe, of course partisan, of course violation to impartiality. And in the future, I think Constitutional Court must consider to form 3 justices assembly to avoid the similar cases. Okay, thank you. This is my presentation, and terima kasih. Okay, moderator, back to you.
Well, now let's give a round of applause one more to the 3 speakers. Well, now we come to the last session. This is discussion session. And we've received one question from Pak Yon just now. And before continuing, the other person to ask question, let's give this microphone to the speaker to answer the questions from Pak Yon. Will you answer the question? Okay. Sasha first.
Thank you very much, Payon, for the question, and thank you very much, Pa Aidul, for your very interesting talk also in this last session. As far as the question has been relayed to me, I think I didn't understand all of the comments that you made along with them. But the question first: does the Constitutional Court that I've been talking about, the Constitutional Court in my country, also have the final and binding position, or do their rulings have final and binding nature? Yes, they do. However, there are various modes in which the Constitutional Court in Germany can decide. First of all, and here I would like to link with something that Paferi has, I think, very correctly stated, the Constitutional Court should never have itself put in a position where it has to fill the seat of the legislator. When the DPR and the president leave the decision about rules to augment the 40 years age limit to the court, they basically invite the court to do something that that court should not do, that is make positive rules, right? Other than just interpret the law. In Germany, in a similar situation, the court would find potentially, if I don't think they would, but that's what could happen. They could find that a law is unconstitutional, for example, because it is discriminatory, and then give the legislator, for example, a maximum of 3 years or 1 year to make an appropriate law to rectify this. This happens sometimes. So they would basically kick the ball back into the court of the legislator. That can happen. But otherwise, the sole decision of the Constitutional Court is this, when we're talking about judicial review of legislation, right? Is this legislation constitutional or not? Not what should we have instead? That is not the task for the Constitutional Court. You asked another question about the requirements. Or would you like to translate? Do you need a translation?
The recruitment of the Germany.
Okay, so the question about requirements for the recruitment of judges. So first, the Constitution states, interestingly, that the court consists of 2 categories of judges, namely professional judges, so people who have been judges at other courts, usually very high courts before, and that in turn requires that persons have a law degree with the qualification for highest judicial office. That's the one category. And the other category, there the Constitution is very unspecific. It says other members. Now, what happens in reality is that typically all the Constitution judges are recruited either from lower courts or from university professors in the constitutional law domain, which are often also people who have held judicial office before. So requirements, qualification for highest judicial office, or that and a career in academia. That is usually the case. There is the last question. I think this is difficult to answer. If the same case happened, let's say in Germany, what would be different, or what would be the reaction be? First of all, as I said before, the same case couldn't really happen in Germany because first of all, this petition, the right to constitutional complaint, which in a way Indonesia has used Germany as a model, right? But they went further than this, because in Indonesia, the constitutional complaint must be brought by somebody who has been directly impacted in their own constitutional rights by by a decision of a state organ. So probably the person who filed this particular petition would not have been eligible to do that. Now, but that aside, what happens if, for example, a constitutional court judge were to be called to decide in a matter which impacts their family? Well, the code of conduct would quite clearly say that they have to recuse themselves, that they cannot take part in this particular decision. When I think of what Mr. Anwar said in the proceedings in the honorary commission, there he said, well, there cannot be an accusation of being partial because in the Mahkamah Konstitusi, proceedings are only abstract and there are no parties, so there cannot be partiality. Now, let me say, I find this not a very convincing argument. It is a strange argument, because even though there are no parties directly, there are, of course, parties, interested people who benefit from a decision or not. So partiality cannot only be very narrowly defined by saying, okay, one of the petitioners or defendants in a case or respondents in a case is a party and I have a connection to either one, because he would say he wasn't personally related to the petitioner, but that doesn't matter. He was very much personally related and had an interest of a personal nature in the outcome of the case, because it would favor somebody who was closely connected to him. So this argument I find odd. It would not be an acceptable argument at any length in any other court that I know of. If a situation like this were to happen, I think, well, it hasn't happened. We cannot know for sure because I have no precedent to relate to you. But I would say that it would be certainly, very certainly, cause for probably the most serious kinds of sanctions that are available. Yes.
Baik, saya juga ingin menambahkan sedikit, barangkali sebelum menambahkan, saya ingin juga lebih memperjelas kepada audiens penjelasan dari Pak Sasa tadi. Yang pertama terkait dengan pertanyaan Pak Yon, ya. Jadi berkaitan dengan apakah mengenai di negara lain, ya. Contohnya tadi Sasa menyampaikan bahwasanya di Jerman putusan MK-nya juga final and binding. Jadi ini sudah nggak ada upaya hukum lain, apapun yang diputuskan itulah yang berlaku. Cuma dalam konteks ini di MK Jerman sendiri itu hakim tidak sangat membatasi diri, jadi tidak mau campur dengan menambahkan norma baru dalam putusan pengujian undang-undang dalam constitutional review. Jadi ya, jadi hakim tidak akan menambahkan norma baru atau menjadi positif legislator, karena ini adalah wewenangnya parlemen atau DPR. Jadi saling menghormati tugas dan fungsi masing-masing. Hakim hanya akan menyatakan bahwasanya pasal ini atau undang-undang ini bertentangan dengan undang-undang dasar. Nah, kemudian lebih jauh saya juga menyampaikan tadi bahwasanya di Jerman untuk rekrutmen hakim itu hampir sama juga. Ada hakim karir, hakim profesional, dan juga dari akademisi, biasanya itu adalah profesor-profesor hukum di universitas. Kemudian tadi Pak Sasa juga menyampaikan tadi dalam konteks pelanggaran kode etik ini, ya, dalam perbandingan, ya. Jadi beliau intinya menyampaikan bahwasanya itu kalau ini di Jerman belum pernah ada ini. Kita sudah agak sering, tapi kalau di Jerman belum pernah ada. Jadi di sana smooth, lancar lah gitu untuk kode etik nih. Hakim itu memang orang yang tidak tercela dan berintegritas yang sangat tinggi, ya. Jadi kalau ini sampai terjadi di Jerman, ini sudah dianggap sebagai pelanggaran yang sangat serius, ya, udah memalukan nih. Nah, jadi itu yang beliau sampaikan. Barangkali tambahan dari kami, Pak Yon. Jadi untuk kita ketahui bersama juga kalau di Indonesia memang putusan final and binding ini kan sudah dinyatakan juga di Undang-Undang Dasar bahwasanya putusan MK itu tingkat pertama dan terakhir yang sifatnya final dan mengikat, dan itu dipertegas lagi di dalam Undang-Undang MK sendiri. Nah, dalam konteks adanya pelanggaran kode etik, tentu kita juga tidak bisa memberlakukan ketentuan pasal 17 ayat 5, 6, dan 7 dari Undang-Undang Kehakiman sendiri. Karena di MK prosedurnya juga tersendiri. Jadi tentu Profesor Aidol juga sudah menyampaikan tadi, beliau menyampaikan bahwasanya tentu putusannya MK atau Majelis Kehormatan tidak akan bisa menganulir putusan dari MK itu sendiri. Barangkali itu tambahan dari kami, sedikit juga terlewatkan. Kalau di Jerman juga dikenal adanya constitutional complaint, gugatan dari warga negara dalam perkara konkret. Jadi diawali dari perkara konkret, apakah perdata atau pidana. Nanti habis di Mahkamah Agungnya kalau masih pihak yang ini merasa dirugikan hak konstitusionalnya tidak setuju, setelah putus kasasinya di Mahkamah Agung, pengadilan Mahkamah Agungnya, mereka bisa melakukan constitutional complaint namanya. Jadi constitutional complaint ke Mahkamah Konstitusi Jerman. Nah, ini bedanya kalau di Jerman. Kita pengujiannya abstrak. Kalau di Jerman dua-duanya ada pengujian konkret, yang constitutional complaint, ada pengujian abstrak. Kalau di Indonesia kan model pengujian undang-undangnya ini abstrak. Jadi langsung diajukan apa. Jadi memang seperti itu. Mungkin barangkali ke depan apakah nanti perlu juga diadopsi model seperti ini. Itu saja barangkali tambahnya.
Okay. Now that's the answer for Mr. Pak Yon's question. Now I will invite the audience to give questions. Prof. Aidul, do you have opinions on the question?
I have no, because I don't know about the question. I come too late to session. Okay, the next session.
Okay then. Okay, so the next session for the question, please. And for online audience, you can also ask question. Okay, please. Ari, wait a moment, guys. Ari Wirya Dinata, please. No, we cannot hear you yet. Turn on your microphone. Unmute your microphone.
Okay. Okay.
Okay, now better. Yeah.
Hello, very good morning, everyone. My name is Ari Wiryadinata, junior lecturer at the Constitutional Law Department, Faculty of Law, Universitas Bengkulu. It is such an honor to be one of the participants in international seminar that organized by this university and also collaborations with my university. My questions goes to Professor Sasa Hart. I'm just wondering about the subjects of the investigations in the violence code of ethics in the Constitutional Court or Supreme Court in Netherlands and also maybe another European Union court. Because in Indonesia, as the example, the case of the violence code of ethics based on the previous case, the subject is only the judge or the justice of Constitutional Court. Meanwhile, we know that this issue is not only involve the justice only or judge only, but also there is a staff under the Constitutional Court itself. So that's why Professor Jimli said that maybe we need that to extend the subject or the jurisdictions for the violence of code of ethics in the Constitutional Court is not only for the judges, but also can see the staff or another people who involved in the code of conduct violence. So what do you think about this issue? This is the first question. The second question is about the abusive judicial review issue, because Professor Dixon also talked about this one, right? The phenomena where the abusive judicial review happen in many democratic countries. Does the phenomena also happen in the Netherlands and also another European Union? Because in Indonesia, I think that there is the massive judiciary review, abusive judicial review issue, or maybe not only abusive judiciary review process, but also the abusive presidential power, where the president try to use any tools or any policy to influence the process of democracy in Indonesia. Does this phenomena is common or being happen also in some democratic countries in European Union or European countries? I think that's all. Thank you so much.
Thank you.
Now,
Thank you very much for. Should I answer first? One more. Okay. Yeah, should we hear another question, or should I already answer?
Yeah.
All right. So thank you very much, Ari, for these questions. So first of all, yes, I very much agree that there must be procedures in place, and I believe that in most judicial organizations in the world, which encompass, as you say, not only judges, and certainly not only constitutional judges, but also staff at other levels at the court institutions, require the existence of disciplinary procedures. Pak Aidul already indicated that for judges at a lower level than the Constitutional Court, this is a responsibility of the Judicial Commission, at least when it concerns the judges, if I understand correctly. I'm not sure if this extends also to other staff. But this is actually similar in other countries that I know. So it is judicial commissions. It is also other types of self-regulatory organizations within the judicial organization. Because as I said before, disciplining judges always has a double-edged thing to it. On the one hand, we may not interfere with the independence of judges, because that's the whole point of having the rule of law, is an independent judiciary. So you cannot easily take somebody from the other branches, investigate and discipline members of the judiciary. On the other hand, there is a need to investigate and discipline them when cases like this arise. So judicial commissions, which by themselves have also the requirement of being very independent, right? Independent from executive orders, independent also from the opinions of the legislators, are very important in this regard, both for, well, as far as I'm concerned, for judges all the way down from the Constitutional Court to any district court, including also court officials. Your second question, well, yes, all of these things happen elsewhere in the world as well. Abusive judicial review, if I interpret this as judicial review, which, for example, is politically motivated. And here we must be careful, because with judicial review, we're basically always in a territory which is of a political nature. We are facing cases which almost by definition are hard cases. If the cases were clear, it wouldn't end up usually in front of the constitutional adjudicator. So you barely have any cases which don't have a political aspect. However, does this mean that constitutional adjudicators always decide in a clearly personally motivated political manner? No. I think we can see instances of what you call abusive constitutional review. I think many people, for example, in the US, are of the opinion that the latest decision that rescinded and overturned the precedent in Roe versus Wade in the US was particularly such, was one particular instance of such a case. On the other hand, in a stare decisis system, in a common law system, there is of course the possibility to come back, that courts later come back to their earlier opinions and overturn them. So what is abusive is tricky to say, but using the facility of judicial review to torpedo, as it were, certain laws, or to torpedo the basic structure of the democratic system of a state, yes, this is something that happens, especially also in systems where courts have been tampered with. And here you see the connection between how judges are appointed and the kind of mandate they hold and where they come from and who they answer to politically, and the substantive judgments that they later made. We see, for example, that usually when you have tendencies of political actors to limit democracy or do away with democracy and establish an authoritarian regime instead, and this does by far not only happen in countries like Indonesia, it happens in Europe as well. We have seen it in Hungary. We have seen attempts of doing so in Poland. The first thing that happens is either undermining the authority of the court, for example, by tampering with the rules on judicial appointments. For example, in Poland, the first thing a new nationalist authoritarian government did was issue laws that forced many of the established constitutional judges to retire early. And when this was contested by the European Union, they devised other measures up to ignoring rulings of the Constitutional Court. Elsewhere, what happens is court packing, for example. Right? In Hungary, what happened from 2011, when a certain political party of the prime minister had an absolute majority and was able to do so, they also forcibly retired large parts of the court and packed the court with sympathizers of their own party to have the court on their side. And also, they established a committee which so it's not only in the Constitutional Court, a committee which would decide which case would be decided by which judge, which of course can also help a great deal in getting politically favorable rulings. So these are examples of the interconnection between judicial office and abusive procedures. I think, well, there's abusive constitutional review. There is, however, also the problem that in some countries you do not have any constitutional review, or in constitutional review which is too weak. You ask about the Netherlands. The Netherlands does not only have no constitutional court, the constitution says explicitly, Article 120, the judge does not enter into the review of the constitutionality of statutes. So constitutional law, constitutional review is prohibited in the Netherlands. In the UK, due to the doctrine of parliamentary sovereignty, for example, you have also no constitutional review. So there are systems which do without this, but in the Netherlands, it might very well happen that if the legislature, which is now the highest interpreter of the Constitution, were to turn authoritarian or were to turn anti-democratic, anti-constitutional, that the Netherlands would be pretty much left without a good remedy. So the presence of constitutional review, and I'm aware that I'm saying this as a German, we have a strong constitutional court, which is not only strong, but also very popular, usually. The presence of constitutional review is a useful thing to have, but it must be organized I think it must be organized in a good way.
Baik, Baik, mungkin saya terjemahkan sedikit untuk lebih memperjelas. Jadi Pak Sasa sudah menyampaikan tadi mengenai untuk Judicial Commission ini sudah menjadi hal yang jamak sekarang di berbagai lembaga peradilan yang ada, termasuk di Uni Eropa sendiri. Ya, jadi merupakan sesuatu yang sudah jamak dan lazim terkait dengan penegakan kode etik dan perilaku hakim. Memang tugasnya seperti itu. Kemudian yang kedua mengenai abuse dalam judicial review ini, saya juga menyampaikan tadi bahwasanya hal-hal yang politis memang itu sangat mempengaruhi juga ya dalam judicial review itu sendiri. Jadi karena bagaimanapun pembuatan undang-undang itu merupakan sesuatu yang sifatnya politis. Tapi kalau misalnya di Jerman itu hakim sangat membatasi diri dalam konteks ini, apalagi sampai menjadi positif legislator dengan menambahkan norma-norma baru. Nah, tadi beliau juga mencontohkan di Amerika Serikat sendiri, di US Supreme Court ya. Jadi pernah ada beberapa kasus juga yang itu putusan-putusannya dimotivasi oleh hal-hal yang sifatnya demokratis. Kemudian ini juga sebaliknya di negara lain seperti di Polandia dicontohkan tadi Hongaria, ini pemerintahannya juga lebih karena mungkin lebih agak otoriter, jadi agak mempengaruhi juga dari Mahkamah Konstitusinya sendiri. Nah, kalau di Belanda beliau menyampaikan ini tidak ada judicial review atau constitutional review karena memang hakim menurut Grondwet Belanda itu menurut undang-undang dasarnya memang dilarang untuk menguji keabsahan undang-undang. Jadi juga dinyatakan bahwasanya the wet is on standby ya, undang-undang tidak dapat diganggu gugat. Jadi penafsir tertinggi dari undang-undang itu kalau di Belanda adalah parlemen sendiri yang membuat undang-undang. Baik, kita lanjut ke penanya berikutnya.
Oke. Lanjut dulu ke penanya online. Silahkan on cam, Fat. Okay. After this, we have offline question from the audience. Turn on your microphone, Fat. Unmute. Unmute your microphone and then speak. Okay.
Baik,
Ya,
terima kasih, Miss Susi. Pertanyaan saya untuk Dr. Sasa, apa itu moral, apa itu konstitusi, dan di Eropa, apakah konstitusi itu ditegakkan dengan moral atau sesuatu yang lain? Terima kasih, Miss.
Thank you very much for the question. Now there is a certain mismatch between the length of the question and the complexity of the question. This is an extremely complex question, even though it's a very short one, right? Let me try answering this. There is, of course, a certain morality enshrined in a constitution. And of course, constitutions can also give or can be inspired by different moralities, or at least they weigh moralities or different moral principles unequally strong. Let's compare, for example, the US Constitution, which has a very strong Bill of Rights that focuses on individual rights, such as freedom of speech, the right for individuals to bear arms, all the classic liberty rights. But instead, they do relatively little when it comes to when it comes to, for example, clashes of rights. So in typical European constitutions and the fundamental principles enshrined there, you see slightly more balanced approach between public welfare, for example, and individual rights. So that, for example, freedom of speech in European constitutional systems is more limited because hate speech is prohibited, whereas much which we consider hate speech would be free in the US. So there is morality in constitutions, but it's not always the morality. It's a particular type of moral principles which constitutional drafters value over others. So constitutions always reflect choices. So does the Indonesian constitution. For example, if you look at the Pancasila principles, which also represent a certain state aim and state reflect a moral system as well. The problem with morality and constitution is that the meaning of constitutions can change over time. Even if we try to be originalist and try to read constitutions as they were meant by the drafters, we do so from the perspective of our time. So it is almost impossible for a constitution to remain the same over time, regardless of how you interpret it. Well, a constitution is more, however, than just a collection of moral principles. A constitution is also a direct, positive, and ideally enforceable legal document. It is also a collection of legal rules which should be reasonably independent of anybody's moral opinions, because it also has that function of positive law, right? And that we shouldn't forget.
Baik, Pak Sasa sudah menjelaskan tadi memang moral itu sangat mempengaruhi bentukan maupun substansi konstitusi sebuah negara. Jadi tidak bisa dilepaskan antara moral dengan konstitusi itu sendiri. Jadi seperti di Amerika beliau mencontohkan tadi konstitusinya itu fokus kepada individual freedom, kebebasan individual. Jadi freedom of speech, freedom of want, freedom from fear, ya. Jadi ini sangat mempengaruhi konstitusi Amerika. Sementara di Eropa misalnya itu ada sedikit keseimbangan antara public welfare, kesejahteraan masyarakat dengan hak-hak individu. Nah, begitupun juga di Indonesia landasan moral ini seperti yang tertuang di Pancasila itu mempengaruhi bentukan materi dan substansi konstitusi itu sendiri. Tapi konstitusi itu tentu tidak akan selalu istilahnya tetap ataupun abadi, ya. Jadi juga mengikuti dinamika yang ada yang disebut sebagai suatu the living constitution. Jadi tentu dinamika kemasyarakatan akan mempengaruhi, seperti halnya kita tahun 1999 2002 itu mengalami amandemen konstitusi sebanyak 4 kali. Di Amerika kalau nggak salah amendemennya sudah 27. The basic law of Germany changed and amended for 50 times, 51. Ya, di Jerman sendiri kalau nggak salah udah puluhan kali dirubah itu sejak konstitusinya, malah sesudah Perang Dunia Kedua. Jadi sudah dirubah sudah puluhan kali. Jadi ini adalah the living constitution.
Okay. Now I would like to invite the audience in this hall to ask question. Please raise your hand. The man at the back. And Sonia, two questions. The man at the back, he is really spiritful. Okay. Yes. Yes, Sonia, and yeah.
Yes.
Assalamualaikum warahmatullahi wabarakatuh. I have a question for Mr. Sasa. Professor, let me introduce myself. My name is Citra Sunya, and I'm a 5th semester student. Okay, thank you in advance for your explanation of the dismissal and disciplinary action against constitutional judge. So now, what is the impact of the dedication of the review, the go verdict case, involving violation of the code of the ethic of the court judge, or the same we know it was all done by Anwar Usman. And he was fired. Correct me if I'm wrong. And then the question is, what do you think the next steps the government can take so that the public can regain confidence in the constitutional court? At least so that our constitution is not degraded. Because we know that some people no longer trust the the constitution in our country, Indonesia. Just it. Thank you, Mr. Assalamualaikum warahmatullahi wabarakatuh.
And last one, you may mention your question. Yes, please. The man at the back. Yes.
Let's check. But thank you very much, Ms. Susi, for the opportunity. My name is Maulana, and we were met before, Mr. Sasha, at the Zoom, but finally, such a pleasure and an honor to finally meeting you meeting you in person. Okay, regarding the rules of decision of the Indonesian Constitutional Court, which recognized as the final and binding decision. So seeing the ethical violation committed by the Constitutional Court judges doesn't affect at all the results of decision. So because the decision is already final and binding. And this rule is, in my opinion, is very super absurd and doesn't make sense at all, considering that it is clearly displaying that there are violation of the ethic codes by the judges. So this is more like a football game or football match. It's like a Maradona hand of God goals, for example. So where the goal is already has been authorized and already recognized as the goal. So, but after seeing the recorded camera, there is a referee and all of us know that there is violation has been committed by the Maradona himself. So there is nothing we can do about it. And then the following, my question is, what is your view on the super absurd rule, and is it true that this validates this absurd rule to become more rigid in Indonesian constitutional rules? I mean, will the rigidity of the Indonesian constitution?
Sorry, can you repeat which rule?
The absurd rule, final and binding.
Oh yeah.
Yeah, final and binding rules. So, I mean, will the rigidity of this rule affect of the effectiveness of law enforcement in Indonesia, and compare to what is already in place in Europe, which is much more flexible? And yeah, that's my first question. And my second question, my final question, is as a law student, if we want to continue our studies abroad, especially in your university, Maastricht University, can we ask you for a reference or a recommendation? That's my question. Thank you, Mr. Sasa.
Thank you very much, both askers, for these questions. I'm going to
address them in turn. So first to the question the lady here in the front was asking. I think in your second question, you implicitly already sort of answered your first question, because you first asked what is the impact of this issue surrounding Mr. Justice Anwar, and then in the second question you ask what are the steps that can be taken for the public to regain confidence. Now, so the answer implicit in there is the impact. And I think I see this in this whole discussion. I see it in the reaction in the media, and I also see it in the conversations that I have with colleagues, is of course that the standing of the court itself is damaged, right? There is, of course, in Indonesia already for a longer time, not a complete confidence of the public in the political system. It is not a secret that the political system has its imperfections, as by the way they do everywhere in the world. So this is by far not an Indonesian issue, right? This is a global problem. But Indonesia has particular trouble with dynasticism, for example. It has particular trouble also with money and politics, and there are many countries where this is the case, but Indonesia is clearly one of them. So this whole affair, the ruling itself, the disciplinary action, and the discussion that everybody is having in these election times about the issue is damaging the democratic system. There's, I think, little question about this, that it will not be helpful to people's belief in democracy as a system. It will also absolutely not be helpful to the reputation and the standing of the Constitutional Court as an institution. It has, on the other hand, the Constitutional Court is an institution which everybody knows has had a difficult standing. So, and the Constitutional Court is an institution which is relatively young in this country, and it has to navigate a political landscape that is hard to navigate, that is difficult to deal with. I think there is, of course, hope for the constitutional system. The mere fact that academia in this country, you, us, that public debate in this country is debating the situation as it is in principle hopeful. So what should happen? I think, and I think this I can combine this with answering the second question about the final and binding rule. So yeah, final and binding nature of a decision where later it has emerged that the process by which the decision has been taken has obviously been flawed. So flawed, in fact, that a senior justice was threatened with dismissal and is facing serious sanctions. Now, such a decision should, of course, in my view, lose its final and binding nature. But let's reflect for a moment, now addressing the gentleman in the back, address for a moment why we have this rule that rulings of a constitutional court should be final and binding in the first place. If we were to say that there is always some manner of coming back to rulings, second-guessing rulings of constitutional adjudicators if there is disciplinary stuff going on around the decisions, that would, of course, be an open invitation to other institutions to discredit judges wherever they can. If it were a viable tool to discredit judges in order to undermine the legal quality of rulings of constitutional courts, that would also not be good. So both sides, there can be overreach on both sides. But this case is relatively clear. This is not a murky, fuzzy, technical case. This is a relatively clear case. There is nothing very, very hard about it. In such cases, yes, of course, my idea would be in the future, like in football, by the way, there should be a rule that makes an exception to the final and binding nature in case such grave violations have been found. In football, in Maradona's time, there wasn't a video evidence technology. Now, later it has been developed, and right now, as far as I'm informed, the FIFA rules do allow for the second guessing of, for example, a goal or an offside ruling by the referee if the video evidence provides otherwise. So there's the possibility for a learning moment in this. I'm not sure it happens, but there is certainly a possibility for to develop the system into a better one. This is tricky, and I would caution against overreach because, as I said, judicial independence and the binding nature of constitutional decisions also has value, right? Because if not, if it can always be second guessed, if it can easily be overturned, then again, we lose the purpose of constitutional review and we imperil the position of the Constitutional Court even more. So a balanced approach to reform, but do reform.
Mr. Susi.
Oh, I didn't answer
Hello,
the
Mr. Susi,
question
Mr. Moderator.
recommendation letters. Now, well, recommendation letters in a blind way, of course, nobody can do. But there are ways to get to Dutch universities, to my university also. Just one piece of information that I can offer. A couple of weeks ago, the leadership, the board of directors of the LPDP was in the Netherlands, in The Hague. I attended a meeting with them. And I heard that they are going to increasingly fund not only doctoral, but also master and even undergrad students, and that they are going to increasingly not only offer full scholarships, of which there are few, but also partial scholarships, of which there can be many more, obviously. So I would invite everyone to investigate this option, in which case the requirement to go to the university is acceptance. And acceptance, if you register as a student, as somebody who has which is adequate, as I assume you have since you are here and already a student, that will be easy to get because our entry requirements are actually free. So you can register as a student if you then find, as I assume many Indonesian students will need, find a scholarship either via the LPDP or any other sponsoring system. It is not that hard to get into the Dutch universities.
Mrs. Susi, can I speak a little? Mrs. Susi?
Yes, please.
Okay. This is regarding the violation of judicial ethics. I think the problem is not only in structure, but in structure of constitutional court and generally the structure of judicial power. The main problem, in my experience as chief of the Judicial Commission, is legal culture. This is concerning behavior, concerning the mindsets, and in the first period of constitutional court, when the chief justice held on by the Professor Jim Lee, I think the constitutional court is very, 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 very good. It's the best, but today, right now, yeah, the constitutional court is this is the the worst performance during the constitutional court history. And the problem is not only the structure, it's not only the facility or the others like IT into online system and etc. But the problem is, I think the most problem is at legal culture or ethic morality. Yeah. I know who is Anwar Usman. I know who is the others justices, but right now I see the decrease of the morality of the justices in constitutional courts, because when I have relation with them when when I am chief of judicial commission, it is I think it is the relation is good. It's very good. There is no problem. So to the right now, the I see the critical situation about the morality, and it is I think this is correlating with correlated with the development of democracy in Indonesia. When we start the Reformation in the Reformation movement in 1999, we have a plan, a plan for to transition to democratic, and we have plan on the 2024 and 2029. We will come to consolidation of democracy, democratic consolidation. What is the consolidation of democracy? The consolidation of democracy is where someone and where everyone in Indonesia, in our country, have one belief that there is one game in our country. There is the only one game in our city, in our country. So when the Anwar Usman violated the judicial conduct, there is the consolidation of democratic is broken, because all of people in Indonesia have this trust for the constitutional court, because after the decision, judicial review decision number 90 to 2023, there is no one only game in our town. There is no agreement, or there is no like agreement, the one agreement about the game, the democratic game, the democratic system in our country. So I think this is the critical situation, because the democratic situation in since the 99 decreased to the I think the low stage, the low situation, and the critical situation. Then and I believe, in my opinion, our country is trend to the regression of democratic, trying to authoritarian democratic. So the problem is not only the structure, because I think the structure of judicial and judicial power, the structure of executive, the structure of constitutional Indonesia is sufficient to create the democratic system. But the problem is legal culture. The legal culture. We have no sufficient legal culture to create the democratic system. We have, like Mr. Sasha said, we have dynasty tradition, we have feudalism. I think it is the like all society a new state, the new modern state. We have all society. We have a feudalistic society in the new the new structure, the new state, the new modern state. So this is the problem. So there is the lack, there is the maybe contradict between the culture, the old culture, and the new modern society. And constitutional court is a product of a modern state, product of modern society. At the same time, we still have tradition, dynasty, tradition of dynasty, tradition of feudalism. It is the problem. So, in my opinion, this is not only the structure. I think the structure of constitutional law in Indonesia is sufficient to create the democratic system, but the problem is legal culture. Legal culture. We have low legal culture. We have low ethics. This is the problem. Thank you.
Okay. Okay, thank you, Prof. Fido. Well, ladies and gentlemen, actually there are a lot of questions come to us just because of the time is over. So I would like to invite the three speakers to mention your final statement on our team today. Please just give us a very brief conclusion. Thank you.
Thank you. I'll do my very best. I try to combine final statement with a brief reaction to what Prof. Idul just said. Indeed, this is a problem of various dimensions. It is a problem of public morality. It is a problem of the design of institutions, and it is a problem of legal culture. And but I would like to distinguish legal culture from public morality, because morality isn't sufficient. So have a high moral standard is not sufficient to establish a good and working and efficient legal system. Legal culture is also about the understanding of the law, because what I see is maybe there's a deficiency in actors, many actors in Indonesia, as elsewhere in the world, when it comes to the point of morality. But there is also a deficiency, or at least no consensus, as to the meaning of the law. Right? Yeah. And so not the content of the law, but an understanding of what law is to us as a society. And I think this is something that is a concern that is addressed, and therefore I'm very happy to be here and to also do the rest of my program today, which is about legal education. This is something that's directly addressed to us as educators. This is something that is our responsibility to bring into society, to have another understanding of the law. In that spirit, I hope that the session today was useful and was instructive to everybody who listened online and here in the room. It was a great pleasure to be here. I think there is the Indonesian system is at a crossroads, right? There are these tendencies towards authoritarianism. There are the clear tendencies towards dynasticism, and there are, of course, not tendencies, but a clear and tangible presence of a lot of money and a lot of decision making where it shouldn't be. But there is also hope. There is institutional debate. There are ideas for reform. So I hope that these developments will take a better turn in the near future. Thank you very much for your attention.
Okay, and then final statement from Mr. Ferry Kova. Oh, Prof. Idol first. Please, Prof. Final statement from you,
thank you.
please.
I think we have code of ethics. The all instrument for the enforcement, the legal judicial ethic. We have code of ethic. We have we have code of ethic for constitutional justices. We have institution for enforcement. Yeah, but the problem is not that. It's not it. The problem is this is the deficiency of morality, deficiency of legal culture, because I think public morality is Indonesia. Indonesia is still good because we have religion, we have adat, we have tradition. Yeah, that's the adat, tradition, and religion contain the public morality, the high morality, the inspire me to the inspiring us to have a high public morality. But the problem is behavioral. Problem is deficiency of moral. This is the problem, and based on in my experience is the problem. Well, I have an experience with one judge in Sulawesi. Yeah, I give him award as the chief of judge in high court, as the best chief of judge, chief of high court. But 1 week later, he detained by KPK as because corruption. So this is the reality of of our nation. So I think I agree with Mr. Sasa. We have to encourage the education for our society, for our children, for our students. But the for instance, for example, the political party in Indonesia cannot they have, I think they have no agenda to give political education for public in Indonesia. And I think this is the example, the role model of Indonesia. The role model of Indonesia is there is no sufficient the role of modern Indonesia to enforcement the morality, to enforcement the ethic. So this is problem. This is my my opinion, the last opinion. Thank you.
And last one, Mr. Parikova, please.
Thank you. So my closing statement first is it is about in the near future. I think the Constitutional Court (MK) should have to limit themselves in adjudication in reviewing the constitutionality of the laws. So they cannot make the decision that or change and created new norms that it is a domain or the competence of the parliament as a legislator. And then the second one, our main problem, I think, I agree with Professor Aidul Fitrusia and Sasha. So our legal culture, maybe it is on personality. So we are still getting trapped into the bad habits such as corruption, collusion, and nepotism. So it is an obstacle for us to regain the public trust on such as constitutional court or other public official or states organ. I think it is have to be fixed in the near future. The I think the way for it is one is by institutionalizing this in education system, such as at the faculty of law, maybe. So the last one, there must be seriousness in everything we do. Yeah. I gave in my presentation before why did the MK decide and gave alternative decision, alternative and new norm. So it is because the DPR and president itself, the government had unseriousness in the trial. So they gave them all to the judge to decide upon that matter. So that's the best decision. So I said this because based on my experience in, although it is in a local government for 25 years. So the seriousness for doing everything is a matter of us in Indonesia. I think that's my closing statement. Thank you.
Well, ladies and gentlemen, let's give warm applause to our three speakers today. Well, thank you, Dr. Sasha. Thank you, Prof. Aidul, for your time. And also thank you, Pak Ferry, for sharing the knowledge. Hopefully what have been shared and explained by the speakers will be very useful for us. And also, yes. And the last session is a photo session. And please take the place.